Now, whenever you get started.
Your Honor,
Yeah. Yana. Mm. Did you get my request checked into?
Yeah.
can you hear us?
Yes, ma'am, I can hear you.
Can you see us good?
By us, I don't see you at all. There you are.
Well, no, I don't want you to see me.
Well, that's not what you said. You said, can you see us?
Can you see Mr. Schmidt and Miss Inglesby?
Yes, I can see them. Camera looks really good.
Yes.
All right, this is cause number CR 18-318, State of Texas versus Tricia Lee Inglesby. We're set for a plea to the
Okay, we're sorry, Judge, you were inaudible.
Can you hear me now?
Oh,
Yes.
So I just called the case and then asked if we were set for plea today.
Yes, sir, we're prepared to proceed.
All right, Miss Inglesby, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thank you. You can lower your hand. All right, your name is Tricia Lee Inglesby, is that correct?
Yes, sir.
And Miss Inglesby, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And in this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done as your attorney?
Yes, sir, we are.
Do you have any questions about the paperwork that you've read over and signed that is your plea agreement?
No, sir.
All right, and Ms. Inglesby, I see that you were before the court on December 18th of 2018. On that date, you pled guilty to the third-degree felony offense of possession of a controlled substance. And the court heard a plea agreement on that day and considered the evidence. The court followed the plea agreement, and the court assessed your punishment at 5 years confinement in prison, along with a $1,500 fine. Court then suspended that sentence and placed you on community supervision for a period of 5 years. And it was also during that period of time that the state filed its motion to revoke your community supervision. And that was, I believe, filed November 30th of 2023. And in that motion, there was one single count of an allegation that would constitute a violation. Have you read over that motion to revoke with your attorney, Mr. Schmidt?
Yes, sir.
Mr. Schmidt, does your client waive the formal reading of the state's motion to revoke?
We waive.
And does she intend to play true to that count?
Yes, sir.
All right, Ms. Inglesby, I see that upon your plea of true today, the state is recommending that upon your plea of true, the state is recommending to the court that your community supervision be revoked, that your punishment be that the state agrees to reform the charge to a lesser offense of possession of controlled substance, penalty group 1 less than 1 gram, and that your punishment be assessed today in section 1244A at 100 days confinement in Van Zandt County Jail, for which you would receive 100 days credit of time already served. You would be ordered to pay the balance of your fines and fees, which would be a $550 reimbursement fee to the county. Ms. Inglesby, is that your understanding of the agreement?
Please, correct. We leave today, right?
Yeah.
Yes, sir. Yes, sir. We understand. Yes, sir.
Okay, and that's your agreement. Is that correct?
Yes, sir.
All right, then, Ms. Inglesby, at this time I would ask you, how do you plead to count 1 contained in the state's motion? Is that count true or not true?
True. Right. Yes, yes,
And
sir.
are you
True.
pleading true to that count? Are you pleading true to that count because what is alleged is in fact true?
Yes, sir.
And Ms. Inglesby, has anyone threatened you, forced you, or pressured you to plead true today?
No, sir.
All right, the court will accept the defendant's plea of true at this time. Mr. Schmidt, any objection to the admission of the evidence?
No objection.
All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Sounds good.
Okay, understand.
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, Judge, just a clarification. I believe, I think she heard you say that the agreement was 180 days with credit for 100. I think you said 100 with credit for 100. I wanted to clarify that for her. It's time served essentially.
Correct. 100
Yes.
days is the record sentence, 100 days credit is what we got, and you would receive time.
Yes, sir. Thank you. Nothing further.
Thank you.
All right, then based on the evidence presented to the court finds that the defendant, Tricia Lee Inglesby, has violated the terms and conditions of the sentence of the community supervision. Court will follow the plea agreement today. The court revokes her community supervision, reforms the original charge to a state jail felony, possession of a controlled substance in penalty group 1 less than 1 gram, assesses punishment under section 1244A at 100 days confinement in the Van Zandt County Jail. Ms. Inglesby is entitled to credit of 100 days and has discharged her sentence with credit for time served. She is ordered to pay the balance of her financial obligations, which is $550 in reimbursement fees. So Ms. Inglesby, when you're released from the Van Zandt County Justice Center, I want you to report to the Van Zandt County Courthouse and come to the district clerk's office and make payment arrangements to pay off your reimbursement fees. Do you understand?
Yes, sir, but I could just.
Mhm.
Oh, yes, sir. We understand that. Yes, sir.
Okay. All right, Ms. Inglesby, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you be fingerprinted, and then once you're released, then come up to the courthouse. If you're released after 5 p.m., then just come the next business day.
Okay.
All right.
It'll be okay.
Yeah, it'll be fine.
Okay. Yes, sir.
All right.
Okay.
You can step over to be
All right.
fingerprinted.
Thank you.
You're welcome.
Okay, sir.
Next time. Get your signature.
Yep. Oh, wait. Yeah, sir.
Rolling.
Yes.
Again.
All right, Mr. Schmidt.
Judge, we're here on, this is Michelle Daly.
All right, this is cause number CR 14-460, State of Texas versus Michelle Daly. We're here on the state's motion to adjudicate. So, go ahead.
That's correct, Judge. And one of the major bases for the state's motion is a new felony offense. I seem to recall, maybe Mr. Hartwell can correct me, whether or not the state has taken that case to the grand jury. Thought that they had, but I can't see it.
Yes, so Your Honor, there is a new charge. I've taken a look at it. My intention is to present that to the grand jury at the next convening of the grand jury, and they'll either no bill it or true bill it, and we'll go from there.
All right, court will set Miss Daly then on the MTA docket October 30th at 1:30.
And then Wendy.
Who's next, Mr. Smith?
This is Wendy Paul. And Judge, she's listed under Mr. Manning's caseload. I'm standing in for Mr. Manning briefly.
All right, this is cause number CR 20-352, State of Texas versus Wendy Marie Paul. State's motion to revoke or adjudicate. Go ahead.
Just my understanding that Mr. Manning has recently been appointed and it was set on this docket day. I'm sure he's not ready. We'd ask that it be reset for that contested docket day.
No objection, Your Honor.
So we're gonna set this one a little bit earlier. We're gonna set this on October 2nd.
Did you say October 22nd, Judge?
No, 2nd. We're gonna do
Okay,
October
thank
2nd
you.
so that Mr. Manning can meet with Ms. Paul. If there's an agreement, that'll be 2 weeks.
Thank you, sir.
Yes. Judge, we can reset Samantha Main. She's in Henderson County. So on your next Tuesday docket to be fine.
Is she in Henderson County being housed, or is she in Henderson County on their?
I believe she's being housed. Yeah, she was unable to be transported today. I think that we were just on an announcement. I would tell the court that I received an offer from the state yesterday. And I talked to Ms. De Silva here, Deputy De Silva, and they intend to bring her back to be housed in Van Zandt County pretty shortly. According to her, that was as of this afternoon. So if we could reset her to the next Tuesday docket, then we probably get something done.
This is cause number CR 25-155, CR 25-169, State versus Samantha Main. Court will reset pretrial to September 30th in each case.
She's not even supposed to. What is y'all saying?
We need just a second.
I'll tell you what, I need to check on something in our office. So I'll send it in 5 or 10 minutes.
Okay, thank you, sir.
I never do. Never.
Your Honor.
Now.
Yes, ma'am.
Okay, we're ready.
Okay. Who would you like to proceed with?
Roy Hamilton.
All right, this is cause number CR 21-71, State of Texas versus Roy LaKeenan Hamilton.
Judge, we
Yes.
haven't, I'm sorry,
Sorry, go ahead.
got ahead of the court. We have an agreement. We're gonna ask that he be set on this Thursday's docket to give us time to get some of the paperwork done.
Okay, any objections from the state?
None, Your Honor. Thank you.
All right, court will set Mr. Hamilton then for later this week on the 18th at 1:30 for plea.
Right. Yes, sir. Thank you.
You're welcome, sir.
Travion Bowie.
Cause number CR 24-198, State of Texas versus Trevion Lakeith Bowie for pretrial. Go ahead, Mr. Smith.
Judge, we have no contested pretrial ask for a Dr. Cosay.
All right, there being no contested pretrials, court sets Mr. Bowie for docket call. You want the 14th, Mr. Schmidt? Go to 14th.
1 second, Judge. Later date. Just wait here. Make your call, dog. It's your choice. Thursday? Yeah. Can we set him for a plea on Thursday, Judge?
Thursday of this week.
Yes, please.
Okay. Court sets Mr. Bowie then for plea on the 18th at 1:30.
Morris Moreno.
This is the State of Texas versus Morris Lee Moreno, cause number CR 24-240, CR 24-241 for pretrial. Go ahead.
No contested pretrial, Judge. Ask for a docket call setting.
All right. Court finding that there are no pretrial motions. The court sets Mr. Moreno for docket call on October 14th at 1:30.
Appreciate it. No worries. Yeah, let's appreciate your help. Casey Smith.
State of Texas versus Casey Patrick Smith, cause numbers CR 25-172 and 173, set for pretrial. Go ahead, Mr. Smith.
Judge, no contested pretrial. We have an agreement with the state and asked to set him for a plea on Thursday.
All right. Court sets Mr. Smith for plea September 18th this week at 1:30.
I gotta be there. Dustin Tinsley. Yeah.
This is cause number CR 25-125, State of Texas versus Dustin Levi Tinsley for pretrial. Go ahead, Mr. Smith.
Correct, Judge. No contested pretrial. Asked to set him for a plea on Thursday.
All right, court sets Mr. Tinsley for plea on September 18th this week at 1:30.
I mean, no, I'm official. I'm not back around. Mark Thomas.
State of Texas versus Mark Aaron Thomas, cause numbers CR 25-17, CR 25-18, CR 25-123, and CR 25-124, all set for final docket call. Go ahead.
That's correct, Judge. And I don't know if the court recalls, but me and Mr. Hartwell have been working on trying to resolve Mr. Thomas for a minute. That's why we're on a final docket call. We have a divergence of opinions about what our agreement was, but we don't have the documentation. The state has made an offer of, I believe it was 7 years TDC, and we believe that the offer was completely different than that. However, we're prepared to announce ready for trial on his cases today, and we'll proceed that way. I would request that the court entertain a plea if we can get, we can reach a consensus on what the actual agreement should be. But meanwhile, rather than continue on docket calls, we'll just put him on the trial docket.
Mr. Hartwell.
That's correct, Your Honor. The only note I have as far as disagreement and what resolutions we were discussing was a note for 7 TDC. I don't have anything else. If we can come up with something where we did agree to something different, state would be unopposed to setting him for a plea.
All right. Court finds that Mr. Thomas has rejected the state's offer. Should there be a desire to enter into a plea agreement, court would expect that to be well in advance of any trial, obviously.
Yes, sir. Yes, sir.
All right, court sets Mr. Thomas for jury selection beginning October 6th. In each case.
There you go, Bobby.
This is the state of Texas versus Bobby Jean Rigby, CR 25-157 for pretrial. Go ahead.
Judge, at this time, I have not filed any contested pretrial motions. I've been in contact with Mr. Hartwell about some of the legal problems I believe exist in this case. I'm going to want to talk to him some more. I would ask the court to either grant me an additional pretrial setting or grant leave to file late pretrial motions in the event that we cannot resolve it between the two of us. Either one of those.
State has no objection to either of those, Your Honor.
All right, court will grant another pretrial hearing October 14th.
Anyone knows that.
Who's next?
I think that the only person we have here that is ready is the writ that I
Okay.
had filed. If you give me just 1 second, Judge.
No, go ahead.
Yes, go ahead.
Yeah, this Abraham wanted to jump in real quick.
Your Honor, this is Roy Mitchell, and he has completed his affidavit of indigency and meets the criteria for an indigent defense attorneys. So I'm going to suggest we appoint Mr. Manning.
All right, very well. CR 25-183, State of Texas versus Roy Mitchell III. Court finds Mr. Mitchell to be indigent at this time and appoints the Honorable Jonathan Manning. Mr. Manning is not scheduled to be in court today. We will reset this for arraignment. Let's set this. Mr. Manning will be here on Thursday, correct, Mr. Graham?
Yes, Your Honor.
We'll go ahead and set him for Thursday as well, so that he and Mr. Manning can meet and review the indictment at the very least, and we can get him scheduled.
Okay. Thank you, Your Honor.
You're welcome.
Thank you.
We don't get everybody, you're right. Thank you, down there.
All right, this is writ number WR 25-32. Dwayne Drennan versus State of Texas. Mr. Schmidt, are you going to be calling Mr. Drennan for purposes of your writ today?
I will, Judge.
All right, Mr. Drennan, if you'll raise your right hand, I'll place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. Yes, Your Honor.
Thank you. Mr. Schmidt, can you advise the people in the courtroom that I can hear, and so it's very difficult?
Yes, sir. Everybody's being vacated as we speak.
Okay, well, let's just wait a moment. Let's let them get out before we get started, because it's hard to hear. Probably the benefit of having a new camera and a new microphone is that it's probably more sensitive and picks up more audio.
Yes, sir. Okay, we're cleared out. You want us to proceed?
Yes, sir. Go ahead.
Mr. Drennan, state your full name for the record.
Dwayne Dale.
Now, Dwayne, you were charged with aggravated assault with a deadly weapon and arrested on those charges on August 13th, 2025, correct?
I was arrested on August 5th in Kaufman County.
August 5th in Kaufman County. And you've been in custody on those charges ever since.
Yes, sir.
Now, your bond is currently set at $20,000. You are unable to make that bond, is that correct?
Yes, sir.
Where do you normally reside?
Roll out.
And that is in Van Zandt County?
Yes, sir.
Do you normally have transportation?
Yes, sir.
Now, previously, prior to filing this writ, you and I discussed the arrest warrant affidavit in your case, and I've reviewed that, as well as Mr. Hartwell with the DA's office has reviewed that. And after our review, you were informed that the state was in agreement with filing a PR bond, an agreed PR bond writ, so that you could get out on these charges while we sort out the issues with the arrest warrant affidavit and the evidentiary issues. You understand that, right?
Yes, sir.
Now, I know that we're not set on an evidentiary writ today, but just for the court, I think some of the issues, the individual that has accused you of this offense, did you know that individual?
No, sir.
Have you ever heard of that individual?
No, sir.
Have you ever even been around that individual?
No, sir.
And the residence that was listed in the affidavit, had you ever been to that residence? Do you believe that the identity was mistaken, or a mistaken identity?
Yes, sir.
And based on my reading of the arrest warrant affidavit, do you believe that the identification was improper as well?
Yes, sir.
Now, are you prepared to present, if court requires it, evidentiary testimony, as well as witnesses and individuals who can verify for the court that the information contained in the arrest warrant affidavit is not possible?
Yes,
In
sir.
other words, it could not be correct.
Yeah, no, there's no way. I've never even heard of the guy in my life.
All right. So at the end of the day, you're unable to make the bond as posted. You're asking the court to grant you a PR bond.
Yes, sir.
Now, if the court grants you a PR bond, this case is unindicted, and it may stay that way. Or is it? That's correct. It's unindicted, and it may stay that way. But in the event that the DA's office determines that it should be presented to a grand jury, you may end up having to come to court to fight these charges. Are you aware of that?
Yes, sir.
And are you able to do that?
Yes, sir.
You have transportation to come back and forth to court.
Yes, sir.
Now, I think that you're also being held on a misdemeanor case in Dallas County. Is that correct?
Yes, sir.
So if you're bonded out of the judge agrees to your PR bond on this day, then you'll have to go to Dallas County to resolve that issue, but it's your understanding that it's already resolved. It just needs your body there to make it
Yes, sir.
happen. So once if you're granted the PR bond and you're transported to Dallas County, once that's resolved, then you understand you'll be on bond conditions still in this county on these charges.
Yes, sir.
And yeah, one of those is you can't do drugs or alcohol. You have to report, pay pretrial fees and all those things. Would you be able to comply with those pretrial
That's
conditions?
not a problem at all.
Judge, I think that the state is prepared to offer as, I guess, writ exhibit 1, the arrest warrant affidavit. I don't have a copy of that to offer on me, but if I would ask in conjunction with Mr. Hartwell that be admitted as writ exhibit 1 from the defense. If they could provide that to the court, you may already have.
I do have a copy. The state has tendered copy. Any objection, Mr. Hartwell?
No objection, Your Honor. Thank you.
And
All right,
Judge, I pass it.
Writ exhibit 1 is admitted, and you said you've passed the witness.
I'll pass it, yes, sir.
Mr. Hartwell, any questions?
Thank you, Your Honor. Just a couple. And I'm sorry, Your Honor, I've got to pull up that document as well. Mr. Drennan, I know you testified that you don't know Mr. Wiseman, who's the alleged victim in this. Is there going to be any issue with a no contact order with Mr. Wiseman?
No, well, I don't know where he lives or what he looks like,
So no issue.
so no issue.
Okay. And you understand that if this case were to be filed, that since you would be out on a personal bond with no bondsman, notice would be sent to whatever address you give the court, and that would be your only notice.
Yes, sir.
And any issues with any of that, keeping the court updated with your current address at all times?
No, sir.
State has nothing further.
Okay. Mr. Schmidt, can you address the other elements of 1715 that the court must consider before considering granting reduction in bond, or actually posting any, say, reduction in bond before setting any amount of reduction in bail? Where he lives, employment, ability to return to the court, criminal history, and then I'm going to have some questions about writ exhibit 1 regarding nature of the offense and the safety
Yes,
of
sir.
the
I
community.
understand that. I believe that is addressed all except for probably his criminal history based on that. And I'd recall, Mr. Jordan, that what is your residence address?
I have it wrote down in there, on paper.
You had it written down on paper. Do you not know what it is?
No, sir, not right off the top of my
All
head.
right. Is it in Rolling Oaks in
Yeah.
Van Zandt County?
Yes, it's in Van Zandt County.
Okay.
I don't plan on returning to Rolling Oaks because I don't want anything like this happening again, because I really don't, like, I don't know where they come up with this information. I think it was just going.
So ultimately, though, this court, in order to grant a reduction or a PR bond, has to have relative assurance that, number one, they're not going to be releasing you as homeless.
Oh,
And you have an actual place, a residence that you can live at. Is that the case currently?
oh, no, I have a residence I live at
And where is that?
in Rolling Oaks.
Okay. Do you live with somebody there?
Yes,
Who do you live with?
Jack Couch,
Jack Couch. Is he a family member or
friend.
roommate?
friend.
Okay. And do you know what road that's on in Rolling Oaks?
It's, shoot, I wish I would have brought it with me.
You have it written down, and if you gave that to me, I could provide it to the court at a later date. Is that correct?
Yes, sir.
All right. And Judge, I'd provide that to the court. He doesn't recall the actual physical address. As far as transportation is concerned, getting back and forth to court, how would you do that?
Either I would drive myself or Jack Couch would drive me.
Okay. Also, as you heard the judge say, one of the things he has to consider is your criminal history. I don't first of all, no, I understand that the court would consider that, Judge. However, through previous testimony, as you've been made aware, Mr. Drennan is being held on a misdemeanor charge out of Dallas County. As far as going through his arrest record, I don't believe that it'd be appropriate for me to do that, simply because any admissions under oath pertaining to prior convictions would prejudice him in any future proceedings in the event the state attempted to use that information to enhance or whatever. But I would pass the witness again if the court would like to ask those questions. I would advise Mr. Drennan to answer them, as those documents are easily produced. But I don't believe it appropriate for me to go into that.
Well, what I'll do then is I'll just request the criminal history to be run according to the public safety report system, and I'll do
Yes,
that.
sir.
But both you, Mr. Schmidt, and you, Mr. Hartwell, are familiar with his criminal history, and you are making that recommendation to the court, having full knowledge of whatever his criminal history is or isn't.
As his attorney, as his defense attorney, based on the testimony of Mr. Drennan and my viewing of the arrest warrant affidavit, I fully recommend that the court grant the motion as requested, but I would defer to the state for their response. I jumped in. Sorry.
And Your Honor, I would make that recommendation. And the kind of the driving force behind me agreeing to a personal bond here is, in looking at this PC affidavit, I'm skeptical that it's a case that I could bring. Now, I can't make a final determination without an entire case file. There may be more information. There usually is more information for me to make a final determination. But based solely off of this, I'm skeptical that the state would be proceeding with charges. I just don't have enough information to do a rejection, which would negate the need for a bond in this situation.
I understand, but the difficult position that this court is in is I have the recommendation of each of you for a personal bond, but I have evidence offered that says that it's a alleged crime of violence, of a threat of murder. And so should this information turn out to be true, then it would leave this court taking your recommendations, but having evidence that it doesn't know whether it's legitimate evidence or not. So I'm going to have to consider, hang on, I'm going to have to consider this evidence. I'll consider the PSRS criminal history and take your recommendations for what they are. But that's the difficult thing that courts have to deal with, especially under the revised laws with regards to issuing personal bonds, especially with crimes of violence or threats of violence. That courts have really been restricted on that ability. So, Mr. Schmidt, you were going to say something?
Yes, Judge, and I understand the court's position. What I would say is that normally, potentially based on the nature of the charge, a better vehicle for this would be a evidentiary writ. And we're prepared to do that as well, Judge. However, based on our agreements with the state, I didn't believe that it ultimately would be necessary. However, if the court believes that is necessary, based on the status of the bail laws, then we would more than likely file an additional evidentiary writ and ask that to be set. But I think, long story short, the most expeditious way that me and Mr. Hartwell believed that we could do the right thing by Mr. Drennan and make sure that the state covers their bases on their case is to have him at liberty while we figure out the mess that I believe the accusations are.
Yeah, and I guess the issue is it's easier for you in the state to get your agreement, but it's harder for the court to comply with 1715 legislation. It'd be different if the evidence that you submitted was not as serious as a threat to commit murder, that Mr. Drennan is a known, individual resident of the county, employed, good standing, good character, all of these things that we know that courts have to take into consideration. But what's difficult is that I can't just approve an agreement because each one of you think that it's okay. Unfortunately, I have to go by what is in the record, and what's in the
Well, Judge-
record besides recommendation is an affidavit that says that Mr. Drennan has been accused of threatening to kill someone.
And I understand that,
Now, and
Judge.
I understand there may be a misidentification issue and all that, but obviously that's not before the court today. That's something that law enforcement has to address.
Well, and I understand that as well, Judge. And I guess what I would ask the court to do is to recess these proceedings, reset it for an evidentiary, and then we provide additional witness and testimony as to the probable cause, so that the court does not have to consider just the 1715 bail considerations. Because right now, I mean, based on what I've read on the affidavit and after speaking to Mr. Drennan, I don't believe that an offense was committed by Mr. Drennan. So, I understand your position, but we would ask to be recessed, and we could set it for an evidentiary, and we present actual live testimony to the court.
Mr. Hartwell, I could set it as soon as the second for the evidentiary docket. That's 2 weeks. That's it's a little 2 days and 2 weeks. Do you believe that you'd be able to get your evidence together to be able to have a full hearing on a probable cause?
Your Honor, between Mr. Schmidt and myself, I believe we can probably get what witnesses are needed to present evidence to the court.
Okay. All right. Well, I appreciate counsel understanding the situation that the court is in. The court will then recess this hearing till October 2nd at 1:30, and we'll continue. If there's a disposition regarding the pretrial detention of Mr. Drennan, then just notify the court that we don't need the hearing, and then we'll take it off the docket. Otherwise, bring your witnesses and let's get a little more information before the court regarding this identification issue.
Yes, sir. Thank you. It's DEWA. So. Okay, but you gave me their names and numbers, correct?
Yes,
On my notes, so I'll make them.
Mother, the address.
That's it. Okay, you're good. Okay. Yeah, paperwork on that? I know they have to do.
Who has it?
You got the paperwork? Look like you're not interested. Be excited. This is.
Must be listening. You got me talking.
Judge, we have Shakol Sampson, and they're bringing her in, I believe. We're gonna go
Okay.
over the amendment real quick and then we'll be ready.
Okay, just notify me when you're ready.
Thank you, sir.
Your Honor,
Yes, ma'am.
okay, we're ready.
All right, this is cause number CR 22-227, State of Texas versus Shakol Monique Sampson. And we're set for a plea today, I believe. Ms. Sampson, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. All right, Ms. Sampson. In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with Mr. Schmidt and the work that he's done for you as your attorney?
Yes.
Do you understand the agreement that you're asking the court to approve today?
Yes.
And it appears that the agreement on your motion, are y'all getting feedback on your end, Mr. Schmidt?
No, sir.
Is there anyone
I
else?
am, Your Honor.
Is there anyone else in the courtroom talking?
No, there's someone in one of the tanks outside that's having a very exciting time. She goes
Oh.
up and down in volume.
I don't hear that. I think I'm just getting some feedback. You hear it, Mr. Hartwell?
I do, Your Honor.
All right, we'll try it again and see. All right, so Ms. Sampson, the state filed a motion to adjudicate your guilt. And today it appears that they're agreeing to withdraw that in exchange for your agreement to extend your community supervision for a period of 2 years, placement at the substance abuse felony punishment facility, which is known as SafeP. And you would also have to amend your conditions to include attorney fees of $500. Is that your agreement, what you're asking the court to approve?
Yes.
All right, Ms. Sampson, has anyone threatened, forced, or pressured you to make this agreement today?
No.
All right. Anything else from the state, Mr. Hartwell?
Nothing further, Your Honor.
Mr. Schmidt, anything further from the defense?
No, sir.
All right, then court finds that the state has filed a motion to withdraw the motion to adjudicate. There is an agreement in the case based on that motion to adjudicate that the motion will be withdrawn, that Ms. Sampson's extension, her community supervision be extended for a period of 2 years, that she will be placed in the SafeP program, and she will incur new attorney fees for this motion in the amount of $500. The court hereby grants that motion, extends the community supervision period of Ms. Sampson for 2 years, orders her to be placed in the substance abuse felony punishment facility, and orders her to pay $500 in new attorney fees. And the court is signing the order on the state's motion this day. All right, Ms. Sampson, you have an opportunity here. Okay, I want to talk about what that is. All right. What do you think the opportunity is that you have today?
Better my life, maybe move plan, and commit to it, which I am, not just for me, but my daughters. I do have
many
a plan and a goal. I have 2,
Okay. How old are they?
12, and 14.
12 and 14. And what did you say? I think I cut you off. You said that you do have a plan.
Yes, I do. I
Okay,
do
can I
have
hear
a plan and goal, just to have a better mindset to get me going, making use of what I'm about to do. So I've learned my lesson, and I accept it.
Okay. Well, I'll commend you today, Ms. Sampson, in taking a huge step in the right direction, not only for yourself and your sobriety, but also for your daughters, in showing them how to take responsibility for their actions and how to repent from those actions and try to make it right. Not only is it trying to make it right, you're trying to make yourself better by being a sober individual, not only for yourself, but for all of those around you. You are a role model for your daughters. So this can be a positive. It started off as a negative thing, but I think they could end in a positive thing. It really can. They can be proud of you if you go down there and you put in the work. And, you know, being in rehab is probably the easier part. It's when you come out of rehab and you're back into your life situation and back into the surroundings that were here when you went into rehab. That's when it's going to be difficult. And so I hope that when you go down there that you actually take advantage of the education and training they're going to give you, and the cognitive, the mental things about how to deal with and combat your addiction, and how to, you know, make changes in your life to prevent you from being, you know, another statistic in the system with relapse and going through those things. So wish the best for you, and hope that this really does benefit you and enables you to get sober and stay clean, and then move on with your life. Okay. All right. So I'm not going to tell you good luck, because I don't believe in good luck. That's not something that I think just happens. I'm going to tell you that go down there and work hard, and you will get results. Okay.
Yeah.
All right. All right. You have a good day. Thank you, Mr. Smith.
Thank you, sir. So we're looking at, really short. So this should be, it's a policy. I'm not understand. They don't have you, God, do a bad problem.
Stay Bram.
Yes, sir.
Camera looks good. I like the setup where they can sit down and relax and use the table to sign. So I like that. And you said that Scott paid for the camera out of his budget. Is that correct? All right. So I
Yes, Your Honor.
just want to publicly thank our IT director, Scott Slayton, for getting us fixed in the jail, for giving us a quality camera and microphone, and for jail staff for helping us get all that set up. All right. If there's nothing further, then we are adjourned. Thank you, Mr. Hartwell.
Thank you, sir.